Under GDPR, how are decisions made by supervisory authorities regarding fines for non-compliance communicated to entities outside the European Economic Area, EEA, and what mechanisms ensure their enforceability? A. Decisions are communicated via international law enforcement agencies, relying on mutual legal assistance treaties to ensure enforceability. B. Supervisory authorities directly notify the non-EEA entity, and fines are automatically enforceable under international law. C. Fines are communicated through designated representatives in the EU, and enforceability is secured through binding corporate rules, BCRs, that include provisions for penalties. D. Entities outside the EEA must appoint an EU representative who receives such communications. Enforceability is facilitated through international cooperation frameworks and adequacy decisions that may include reciprocal enforcement of fines and penalties. Correct answer, D. Explanation: GDPR mandates that entities not established in the EU, but subject to its jurisdiction due to processing activities related to offering goods or services to, or monitoring the behavior of EU data subjects, appoint a representative within the EU. This representative acts as a point of contact for supervisory authorities, including for communications regarding non-compliance and fines. The enforceability of these decisions outside the EU relies on international cooperation mechanisms, such as adequacy decisions, which might include agreements on reciprocal enforcement of fines and penalties, or on other legal mechanisms that ensure the effectiveness of GDPR's extraterritorial provisions. Under GDPR, how is the responsibility for data breaches that involve multiple data controllers jointly determined, and what are the implications for data subjects seeking redress? A. Each data controller is individually and fully responsible for the entire breach, allowing data subjects to seek full compensation from any controller involved. B. Responsibility is apportioned based on the percentage of data each controller was processing, with data subjects required to claim compensation proportionally from each. C. Joint controllers must designate a lead controller to take full responsibility for any breaches, simplifying the process for data subjects. D. Joint controllers are jointly and severally liable for the entire breach, meaning data subjects can seek compensation for the full amount of their damages from any of the controllers, who then must seek contribution from the other controllers involved. Correct answer, D. Explanation: under GDPR, in cases of joint controllership where multiple entities are jointly responsible for the determination of the means and purposes of processing, they are jointly and severally liable for any breaches. This provision ensures that data subjects can seek and obtain full compensation for the damages caused by processing operations that infringe on the regulation from any one of the joint controllers. The joint controllers involved are then responsible for determining among themselves the portions of the compensation to be paid by each based on their respective levels of responsibility for the damage caused by the breach. This mechanism is designed to protect the interests of data subjects, providing them with a straightforward path to obtaining redress. Under GDPR, in what situation is a legitimate interest assessment, LIA, most critical for justifying processing activities? A. When processing is necessary for the performance of a contract to which the data subject is party. B. When the processing involves personal data collected from publicly available sources. C. When relying on legitimate interest as the lawful basis for processing, particularly in cases where the interests, rights, and freedoms of the data subject could potentially override the interests pursued by the data controller. D. When personal data is processed for direct marketing purposes, as legitimate interest is always the lawful basis for such processing. Correct answer, C. Explanation: a legitimate interest assessment, LIA, is particularly crucial when a data controller intends to rely on legitimate interest as the lawful basis for processing under GDPR. This assessment helps to ensure that the controller's legitimate interests do not override the fundamental rights and freedoms of the data subjects, especially regarding their personal data. The LIA involves a balancing test to evaluate these factors, making it an essential process for justifying processing activities under this lawful basis. This is especially important in situations where it's not immediately clear that the controller's interests would naturally outweigh the data subject's rights. GDPR introduces the concept of pseudonymization as a data protection technique. Which statement accurately reflects its role and requirements under the regulation? A. Pseudonymization is considered a fully compliant alternative to anonymization, completely relieving the data controller of all GDPR obligations concerning the pseudonymized data. B. Pseudonymization is a reversible process that must allow the attribution of pseudonymized data to specific data subjects when necessary, provided adequate safeguards are in place to prevent unauthorized re-identification. C. Once data has been pseudonymized, it is no longer considered personal data under GDPR, as it cannot be attributed to a specific data subject without the use of additional information. D. Pseudonymization is required for all personal data processed under GDPR, without exception, to ensure a baseline level of security and privacy. Correct answer, B. Explanation: pseudonymization is defined under GDPR as the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, provided that such additional information is kept separately and is subject to technical and organizational measures to ensure non-attribution. This process is reversible under controlled conditions to allow for the data to be reattributed to data subjects if necessary, such as for the purposes of providing services or conducting research under adequate safeguards. Pseudonymization reduces the risks to the data subjects and helps data controllers and processors to meet their data protection obligations. But it does not exempt the data from GDPR obligations, unlike anonymization, where data is irreversibly altered not to be considered personal anymore.